My lady, my lords, just before the short adjournment, we had alighted upon paragraph 152 of Lord Justice Kitchen's judgment at page 320.
We had indeed.
It's an important paragraph because it's where he draws the threads together, and where if there be an error of principle made by Mr. Justice Burse, one would expect to find it most clearly stated. And we would respectfully submit that what it actually displays is how it is that the Court of Appeal have erred in principle, not the judge at first instance. Can I go to the paragraph itself where Lord Justice Kitchen says, drawing the threads together, I'm satisfied Mr. Speck has made good his criticisms of the judge's reasoning. The judge, he says, has lost sight of the fact on his own findings the claimed invention lies at the end of the familiar path through routine preclinical and clinical trials process. Well, first, with great respect, it's manifest that the judge had that in mind in his analysis, but it wasn't the primary determining factor because it's not the statutory question. And it's the next sentence where it's manifest, where Lord Justice Kitchen is erring away from the statutory question. He says the skilled but non-inventive team would embark on that clinical trials process with a reasonable expectation of success. So what Lord Justice Kitchen is saying, I accept a reasonable expectation of success as part of the equation, but Of what? And this, my lord, is where one has to go back to 146 of Lord Justice Kitchen's judgment, where he said the judge addressed the skilled team's expectations at various points throughout his judgment on obviousness, and he gives the various paragraph references. And he did so overall in relation to particular studies. He found the skilled team would embark on the project with a reasonable expectation of success in establishing tadalafil as a safe, tolerable, and effective treatment for erectile dysfunction. But on the judge's own findings, that reasonable expectation of success is satisfied by 25 milligrams, which is safe, efficacious, and marketable.
I mean, there may be degrees of safety, efficacy, and marketability. You may decide that 25 or 50 or 70 are all safe, efficacious, and marketable. You may well find that they're safer, more efficacious, etc., at lower levels. You're trying out various dosages, not with a preconception that any one of them is likely to produce desirable results. Any one that you can identify in advance, simply to discover the best dosage. And that may well end up, and it's obvious that the lower the dosage, the less likely the side effects of it.
But would it be efficacious? And there may be a range of expectations of success from 100 on the one hand to 5 milligrams on the other, but the crucial aspect of the judge's findings was the skilled person would have no expectation that 10 would be efficacious, let alone 5.
Well, is that the test? I mean, you have to have an expectation about a particular dosage level. If what you are doing is saying, we can find one dosage level, a dosage level that seems better than any of the others. We don't at the moment have any particular expectation about which it would be, but the object is to discover which is the best one.
But the question of expectation has to be judged in relation to the claim subject matter. This is judging the claim. And the question, therefore, as the judge rightly posed the question, is a dose of 1 to 5 milligrams a day likely or expected or obvious as being efficacious?
So you say that you've got to have an expectation before you carry out even the most routine tests about what a specific dosage will be like in comparison to others.
But no, being able to put your precise finger on the button isn't the test. The question is, would you expect something that low to be efficacious at all on the basis of what you know? That's the start question. And the reason I was actually showing the court this sentence is where Lord Justice Kitchen said the skilled but non-inventive team would embark on that process with a reasonable expectation. And as was put to me, the question was of what? And what I'm saying is that the expectation of success, would you establish tadalafil as a safe, tolerable, and effective treatment for erectile dysfunction? That is the limit of it. And that is satisfied at 25 milligrams. And the point I wish to stress to the court is that having stressed the importance of asking the statutory question, is the claim subject matter obvious? What the court is here doing, manifestly, is substituting that for saying, well, expectation of success can be gauged at a level which is not the claim, but is a more abstract notion of safe, tolerable, and effective treatment for ED. And then it's going on to say, in the course of it, they would carry out phase 2B dose-ranging studies with the aim of finding out, among other things, the dose-response relationship. This, again, is substituting the statutory question with the process and saying, well, because you would try and find out the dose-response relationship, and you would have an expectation of finding one, ergo, it follows that 5 milligrams must be obvious. The problem with that approach is it actually cuts away altogether the manifest significance of the technical effect associated with the particular claim, because that is what this does. And it is not to judge the claim by reference to the wording of the claim, it's to judge the claim by the way in which it has been attained. And that is not the statutory question.
Well, I can see the force of that as applied to quite a number of obviousness cases. But if the obviousness is said to rely entirely in the dosage regime, and the prior art is said to consist in a disclosure of Dogan, which is entirely agnostic on the question, what is the proper dosage? So that basically you have to work out what is not just a safe and efficacious dosage, but the most satisfactory one from the various points of view that are relevant. I really do question whether it's necessary to have to start out with any preconception as to what the results of those tests will be as applied to any particular quantity.
We would submit it's not a question of preconception one way or the other.
Right.
And the issue...
Neat preconception, insert expectation.
Well, expectation is crucial because this is the could-would. My learned friend, Mr. Mitchison, showed you that could-would part from the case law book. Would the skilled person proceed on this course with the expectation of achieving the technical effect associated with the claim? And that is why that is so important, and why if you don't follow that approach, which is entirely important, because we have a situation in which 50 milligrams is disclosed in Dogan as formulations. One has a range...
Well, that's an illustrative example.
It's but the skilled person knows that they get no guidance from something that says from 0.001 to 800 milligrams. That's effectively no guidance at all. So therefore, you have the skilled person's expectation that 25 milligrams would be obvious in the light of the disclosure of Dogan. You do not have a finding, as per the Court of Appeal thinking, that it would be inevitable that you would go down to 5. Very likely maybe, but once it's only very likely, it is not inevitable. And then you have to ask yourself the question, well, is actually 5 milligrams, with the associated technical effect that comes with it, obvious or not in the light of Dogan? And it is plainly not.
If that submission is correct, the reality is that it would almost always be possible to patent something with a different dosage.
No, and this is the beauty. My Lord,
going to the opposite end of the spectrum.
And this is the beauty of the European Patent Office's problem-solution approach. Because if there is no technical effect associated, say, with 5 milligrams, it's just an alternative dose, and there's no technical effect associated with it, this is where the boards of appeal in the EPO formulate the problem to be solved differently. They say, it's not to find a better dose, it's to find merely an alternative dose. And finding an alternative dose that has no associated technical effect is almost always obvious. It need not necessarily be so. But this is the beauty of the problem-solution approach, which judges the obviousness by incorporating the technical effect associated with it, and then formulating the problem to be solved relative to that. And this is how it works. And it does work, and this is why it's now effectively law LAW as well as LORE in the European Patent Office. Because what we do see from going back to 152, one sees that the statutory question and the technical effect associated with the 5 milligrams is ripped out and disregarded in this approach. They say in the course of it, they'd carried out phase 2B dose-ranging studies with the aim of finding out, among other things, the dose-response relationship. It's very likely that in doing so they would test a dose, and if they did so, they'd find out it was safe and efficacious. At that point, they would have arrived at the claimed invention. This is all process. It is not outcome. It disregards expectation of success, albeit saying that expectation of success is there. But that expectation of success, as I've indicated in paragraph 146, is of finding a safe, tolerable and effective treatment for ED. Likely or otherwise, there has to be the incentive for the skilled team to do this work. And as I said earlier, once one's into very likely country, you're in obviousness country. And once you're in obviousness country, you have to ask the statutory question. You don't substitute it what Lord Hoffman would call a vague paraphrase of the claim. But this is even worse. It's just, in other things, the dose-response relationship. And what is amazing about this is that in Medimmune, Lord Justice Kitchen and Lord Justice Lewison both said there's only one question, the statutory question. They emphasised that time and again. And yet here we see they're not asking the statutory question, they're substituting it with a process of discovery, which has inherent with it a whole load of other problems. The so-called familiar path is one on which so many inventions are made.
That's right, isn't it?
So, Lord, that we say is wrong. We say the entire focus of this judgment, and we'll come on to look at Lord Justice Floyd, is likewise wrong. The claimed outcome is not merely a dose-response relationship or even the result of a dose-response relationship, but a specific low dose with an unexpected technical effect. And that is what should be judged according to the statute. And none of what is said in paragraph 152 justifies doing so. As I say, the approach of Mr. Justice Peirce was entirely orthodox. He wasn't sidetracked by the course of discovery. He focused on the claim and judged the case accordingly, and we say correctly. So can I then turn to Lord Justice Floyd, because many of the errors essentially are at least overlap and in fact are the same, although some are magnified. The first error, paragraph 160, paragraph 300, page 322. He says he adheres to what he said previously, including Gideon Rick, and says he adheres to what he said. He says there are some steps can be characterised as so routine that a skilled person would carry them out simply because they are routine, irrespective of any prospect of success. An example is routine dose-ranging studies. Well, we say firstly it's wrong again in principle to remove any expectation of success because that strikes so heavily against empirical research. The routineness or otherwise don't provide a proper reason to interfere with the analysis of the judge, and one's starting to substitute other words. What sort of test is, quote, so routine? We all know is now going to have a debate about the spectrum of routineness. There's no guidance here as to when a routine test is not a routine test. You could say that, as was said in this case, preclinical and clinical studies are, quotes, routine. But within them, the specific tests are not routine. To take this case as an example, the learned judge found actually there was no clear guidance or even established thinking as to what a minimum effective dose was for one of these drugs. You only had the guidance of Viagra to go with. And this formed a very major part of the judge's analysis because the argument of Mr. Speck was, well, it was routine to find the minimum effective dose. And here the evidence was there wasn't actually an established means of knowing what a minimum effective dose was. And the importance of this is, again, because the claim here is a claim that is for the treatment of erectile dysfunction. And you've got to be able to judge at what dose, 5 milligrams or otherwise, is it actually a minimally effective or an effective dose for the treatment of erectile dysfunction. So even here, one is going to have this argument about, well, what's the routineness of this experiment? And this is why, if one goes back to the cases that deprecate the substitution of obviousness for other questions, you are substituting a word of routineness, which actually causes as many difficulties as it seeks to solve. The second error of Lord Justice Floyd, and I've touched on this already, in 169, because if one reads paragraph 168, and when I read paragraph 168, I thought, oh, well, we're going to have a different judgment, a different outcome here, because the judge refers to the various findings of Mr. Justice Peirce. And then he says at 169, which is a crucial paragraph, I think it was in these final steps in his reasoning the judge fell into error. The whole purpose of embarking on the routine 2B dose ranging study was to identify a dose response. Well, here again, this is not judging the claim on its wording, it's judging it by its process. The discovery of a plateau indicated the routine study would have to be repeated at a lower dose because it was not complete. Completion of the study would inevitably lead the skill team to test 5 mg a day. And as I've indicated, the judge's finding was flatly contrary in paragraph 327 that it was not routine. This is where he used the words very likely. It was not, therefore, inevitable as the judge held. So one was looking at this, if one's looking at it through the eyes of this judgment, well, this is where you would inevitably lead. And we know this is not a lack of novelty case. The third error of Lord Justice Floyd, also in 169, again, was to judge the question of obviousness merely by reference to the outcome of the dose response curve, and not by reference to the particular low-dose regime which is claimed, with its efficacy and minimal side effects. This, again, we say is contrary to Connor and is wrong in principle for all the reasons I've been over, and that is most apparent from 170. The fourth error, which I've sought to elaborate already, is the superficially high level at which routineness is judged, when in humans there was no established way of even judging the minimum effective dose. It is hard, we submit, to describe the research as routine at a proper and meaningful level. It was only routine in the sense of following the regulatory phases of research, which all pharmaceutical research must do. And that error permeates paragraph 169 and 170. The fifth error is we submit is again to fall into the technograph trap. The very likely language is only after the results of the phase 2A and phase 2B results are known, and the surprising results of which could not have been predicted at the outset. And that is readily apparent, we submit, from paragraph 169 to 172. Again, that approach, we say, contradicts the need to judge the obviousness or not of the invention as a whole at the priority date, not by reference ex post facto to one downstream segment of the research program. That is how it's being judged. And last, and sixth, and overridingly, we submit the judgments in error expressly to substitute the question with the way it's reached. I started by showing the court paragraph 155, where the learned judge applies the statutory question and comes to the view, of course, it was not obvious. And his antidote to that was to say, well, you wouldn't know without conducting appropriate tests what, if any, dose of tadalafil would achieve that goal. And I've indicated to the court that's not correct, because 25 milligrams on the judge's finding would. And one sees at the end of 172, he wraps it up by saying it is true. The judge made a finding the skilled team would be surprised by the results, namely efficacy at 5. However, it's a result which on his findings would be arrived at. Note, the judge is blurring that with inevitably, which is not correct, from 169. Would be arrived at by the standard routine inquiries into dose response which are required by phase 2B. The surprising result, once uncovered, does not make these routine inquiries inventive. Can I make the very obvious point that he is looking for something that is, quotes, inventive? This is rather like the scintilla of invention that Lord Justice Kitchen, or requiring ingenuity, at 139. It's not the statutory question, and there has been a complete substitution from 155 to the end of 172 of the statutory question with this analysis. And this analysis is in error for all the 6 reasons that I've just gone over. Now, lastly, in the judgment of Lord Justice Lewison, I can take this quite quickly. He agrees with the step-by-step approach, if I can put it that way, on the findings, and it's encapsulated in paragraph 180, at MS page 327. This court has been at pains to warn against the over-elaboration of obvious to try. While there are a number of factors, depending on the circumstances, that may bear on the question, it's not always necessary for all of them to be ticked off as a checklist. As Lord Justices Kitchen and Floyd have demonstrated, in a case which involves routine preclinical controls, what would be undertaken as part of that routine is unlikely to be inventive. Again, looking for inventiveness. And this approach, we say, suffers several flaws. First, again, it bypasses the statutory question altogether without justification. Second, the question of whether something is routine as opposed to obvious begs so many additional and different questions to be asked as to what is the meaning of routine and when or how something is to be so regarded. And third, in saying that what would be undertaken as part of that routine is unlikely to be inventive, disregarding the use of the word inventive, Lord Justice Lewison is again considering only the way in which the result was obtained and not the outcome as the statutory question demands. And fourthly, even on Lord Justice Lewison's approach, considering that such a process was unlikely to be inventive, cannot avoid the need to ask whether in fact the claimed invention was obvious or not. And in contrast to his very strict guidance in Medimune regarding the importance of asking the statutory question, at no point does Lord Justice Lewison address it. In fact, having been told there is a single question, is it obvious? We have instead a completely different substitute approach, which is dictated solely by the way in which the result is arrived at. And that, we say, is wrong in principle. And I do seek to stress the value of focusing on the technical effect achieved by the claim in the way that the European Patent Office does, because it enables the court to distinguish between obvious, i.e. expected effects, and non-obvious dosing regimes, as this does. And that's the importance of the Abbott respiratory case. It's the importance of the Wellcome nucleosides case. That is guidance which this court, we respectfully submit, should follow. It is, in fact, rather telling, and we make this point in our case, that we ran the problem-solution approach of the European Patent Office in the Court of Appeal. We ran the cases that we've run before this court, the nucleosides case. And indeed, Lord Justice Kitchen at the end, much to my encouragement, said, well, what do you say about that, Mr. Speck? And he said, well, that's the way they do it there, and that's not the way we do it here. And I respectfully submit that it actually is not a satisfactory approach, and that a lot of guidance should come from the way the European Patent Office decides matters in the way that my learned friend, Mr. Mitchison, has indeed shown you. Now, finally, at section K, I'm moving on from the judgments to policy. And I can deal with this very shortly because it is set out at the beginning and end of our written case. It's clearly addressed in the judgment of Mr. Justice Burse in those sections that I've highlighted. And it's spelt out in the finasteride case, which my learned friend Mr. Mitchison referred to. And indeed, the learned judge quotes at MS 393. The practical reality, it's all very well submitting that, well, you would get to this result. The skilled person would get to this result. The fact of the matter, Glaxo didn't. They had the Dogan patent. In fact, they kicked themselves later because they came along with another drug called Levitra that nobody thinks is as good as Cialis or Viagra. But they gave up the rights to the Dogan patent. And as I've said, Dogan starts with compounds A and B. It takes you off. It has no guidance as to dosing, has no guidance as to what you should do with it. And the practical reality is that the surprising and advantageous technical effect of the very low doses of tadalafil came about only through the costly and time-consuming research of Eli Lilly, which the patent system is intended to reward. And it does and should make no difference as a matter of policy whether the invention is made through a flash of inspiration, by serendipity, by the application of standard research tools, which many would say are thoroughly routine. The respondent's approach we submit cuts against so much of that research, which is being carried on day in and day out in laboratories across the land in the hope that it'll produce valuable discoveries. And again, I stress, why in Connor the whole requirement of expectation of success was stated against the background of Sir Hugh Laddie's article to which my learned friend Mr. Mitchison referred. Provided these discoveries are not obvious and otherwise meet the requirements of the Act, then they should be patentable, irrespective of how they are made, routinely or otherwise. The new technical effect of any given claim, irrespective of the context, must be judged by reference to the statutory question. Doing that correctly in this case, by conventional application of EPO case law and the correct approach in the UK, as the judge has done in this case, can, we say, only lead to a finding the patent's non-obvious and the surprising and beneficial invention set under the claims is patentable. Now, finally, just one postscript, as it were, to save time on the overseas cases. Manager Junior, Ms. Mogridge, has prepared a series of extracts from the cases that have found the low-dose regime patent to be patentable. I can take the court through them from the bundles themselves, but actually these are no more than extracts. It's without commentary. So if I could pass this up and ask the court just to see those aspects, because as is not unusual in a case of this nature, you find one country going one way, another country going another. And my own friend's picture is obviously very much pointed in one direction. So can I just, as it were, level this up a bit? One of these jurisdictions is not an EPC state. That is to say the first one, which is Australia. And what we do is we give the name of the case, we give the bundle at which it's found, and the date of the judgment. And interestingly, at the top of the second page, we quote paragraph 465 of the Australian judgment. I'm afraid it is quite a lot in the bundles. They say, even if a decision was made, this is the Bolden word, to carry out a study of the claimed doses, it would not be a decision made with the required expectation of success. And one sees how expectation of success permeates their consideration. The second one is interesting. This is Eli Lilly against Sandoz, A7 tab 70. And we give the judgment. The significance of this one, actually, it's, of the other jurisdictions, this is the only other jurisdiction, apart from Portugal, which allows cross-examination. Germany and Holland, for example, do not. And after hearing evidence and cross-examination and the submissions, they held, the court finds the specification, this is in the second paragraph, the court finds the specification in claim 10, because this was the same patent under the EPC, of a unit dose comprising 1 to 5, would not have been obvious to a person skilled in the art of Dogan 2, which is the same as our Dogan. They say in the Bolden paragraph there, this means that one could not have determined in advance that routine trials would lead to the invention. And then in the middle, moreover, the skilled person would not reduce the dosage in order to decrease relatively mild adverse effects, as he would expect this also to reduce the effect. It would not be obvious for the person skilled in the art that tadalafil is effective at considerably lower doses than tadalafil.
I think that was the point I was putting to you, Mr.
Yes, yes, it is indeed, my lady. I see that now. And the Dutch court came to that conclusion. And then they go over the page to say, sorry, Danish rather than Dutch. The patent in suit shows the surprising effect that tadalafil can be used daily and is effective at low doses with minimum of adverse effects. This would have been novel for a person skilled in the art in relation to Dovan 2. On this basis, the court finds that Lilly has rendered it probable. The patent has inventive step. Then at number 3, we have a decision of the Polish Patent Office. I think, in fact, that may be the first of 2. The reference is bundle A7, tab 72. Could I perhaps ask the court to read the emboldened language? Then at number 4, we have a decision from the Czech Republic Industrial Property Office. Could I ask the court just to read the emboldened language again? Then at 5, we have a decision of Tevra and ICOS in the Czech Republic.
Is D1 a reference to Dogan?
Yes, these are all references to Dogan.
Yeah.
Then at 5, we have A776, which is from the Czech office.
Well, we have
again.
2 from Poland and 2 from the Czech Republic, haven't we?
Yes.
Yeah.
Now, for the note, we've dealt with Germany and Holland in our reply case, because they are the 2 that my learned friend particularly focuses on. And for the court's note, it's in our reply case, which is at MS 271 to 273. And can I just say there immediately, one of the points we make in respect to Germany is that they made findings of fact that would have led to a finding of obviousness in this jurisdiction, again without cross-examination. They actually held that the skilled person would have included 5 milligrams in the first test with the expectation that it would be an efficacious dose. Well, if that was the finding here, then I don't think any of us would be here. And we also list a number of distinguishing features of the German case in our reply submissions. So far as Holland is concerned, in fact, this came after the Court of Appeal's decision. It reproduces tracts of the Court of Appeal and doesn't provide, in our respectful submission, any independent guidance. Again, done without the benefit of cross-examination. And I think it's also not without note that in Germany and Holland, I'll be corrected, they put in evidence from a skilled clinician. We would cynically say, because you don't have cross-examination in Germany and Holland. In this jurisdiction where we do have cross-examination, we do not decide to put forward a skilled clinician, and we say an inference can be drawn from that. That's the footnote I asked the court to read at the outset. Because if they found there was a clinician who could give evidence that this was indeed obvious, such a skilled clinician could and should have come forward to say so. We had Dr. Brock, who said this was not obvious, and that was tested in cross-examination, and the judge so found. The medic was I'm told it was a medic called Mr. Ian Erdley, who was an opinion former in the field. We knew his name because that had become apparent in the course of communications, but he did not appear at trial, even though, as we said, they had said at the CMC that the views of the skilled clinician were critical. So for all those reasons, we respectfully submit that the judge was right, and in those circumstances, his judgment should be restored. He made no error of principle. Where there be an error of principle, it was made by the Court of Appeal. Now, my lady, I'm told, notwithstanding the clock, I'm 10 minutes early. 2:45 was our finishing time.
Yes.
And what we had certainly agreed in correspondence with the other party, that if either party was early, it could make that time up in reply if it was necessary.
Well, that's normally the situation,
Yes.
because you always all try and use up all the time that the court has permitted you.
I've endeavoured not to do so on this occasion, my lady.
You have, and if you find you don't need to take it up later on too, no doubt that will be suitably noted.
I will bear that in mind.
But don't take any message as to what the outcome's going to be from what I've just said.
I'm obliged.
I'm not giving any indication. Yes. Anyway, thank you very much indeed, Mr. Waugh. Mr. Mitchison, you have already followed. Do you wish to follow any further? Okay, thank you. Mr. Brock?
My lady, my lords, my route map is as follows. I'm going to start by giving you 7 propositions, which I will give a little bit of explanation with as I go through it, that I hope will enable you to see the big picture After that, I'm going to explain the patent system in the round and how obviousness fits in to that system. And in particular, I'm going to take you to 3 cases at the highest level. None of them are directed to obviousness. And that's deliberate because I want you to see how the system overall works. Then I'm going to cover, as briefly as possible, the basic technology and the findings of the judge. And then I'm going to address the obviousness case law and deal with subjects like obvious to try, the Connor case, my friend saying that our case and the Court of Appeal are not judging the invention by the claim, an attack that's in their printed case, and I think certainly the way my learned friend Mr. Waugh put many of his points, it's the attack on Gideon Richter, which is taking into account information that you, as a skilled person, find out along the way. So I'm going to deal with that and why that's permissible. And I'm going to deal with the key case of Actavis and Merck. Then I'm going to address the EPO cases, and as briefly as possible at the end, the foreign litigation, for explaining why there is in fact a link between the points raised in my friend's appeal, and in particular the way he seeks to characterise his invention, and the issues of priority and added matter. My lady, my lords, I'm not going to pursue the lack of novelty attack over Stoner. So that I won't pursue, in particular in the light of judgment of this court last week as to the level of the plausibility requirement for Swiss claims. So with that route map, can I start with my 7 propositions? First of all, proposition 1, patent law is all about technical information that's of use industrially. That is, to enable ordinary, skilled but uninventive members of the public to make products and carry out processes. And at its heart, there's a bargain whereby the innovation is encouraged for the time-limited monopoly. In my submission, what matters is the class of products and processes that the skilled person is enabled to do, firstly, in the light of the state of the art without the patent, and secondly, with the patent. And the difference between those two things is the all-important technical contribution. Proposition 2, there is a symmetry or balance in the system at its heart because of the concept of the enabling disclosure. That is a requirement that arises in all aspects of the assessment of technical contribution. Proposition 3, the monopoly cannot cover that which the skilled person was already able to do or make, having regard to the state of the art. That includes things that are precisely the same as that already made available, but also obvious modifications or additions to that which is in the state of the art. Just by way of explanation, that is one aspect of the fundamental principle that the monopoly must be commensurate with the technical contribution, because if the monopoly extends to things that the skilled person was already able to do in the light of the state of the art, it is going further than that technical contribution. Now, my lady, my lords, what I'm going to use as a shorthand for that, i.e. that which they could already do, is that which is in the skilled person's repertoire. And by that I mean more than simply it's their technical capability if given the idea, because the idea may in fact be part of the invention, or having the idea may be part of their ordinary capability or repertoire. But that's what I mean when I say it's in their repertoire. And consequently, if a patent monopoly extends to something already within their repertoire, it's illegitimate. Now, importantly, that is so whether the claim itself can be predicted or written down in advance of the patent or not. Proposition 4, the position is the same, as I've just described, when all the patentee has done is discover more information about products or processes already in the skilled person's repertoire. Maybe cases where it can be said the patentee's contributed information of that kind. Without more, nothing has been added to the body of products or processes that the skilled person can make or do. Now that principle is broader than the unexpected bonus, but that's why you can't have an unexpected bonus, a patent for an unexpected bonus, because you're just finding out something else about something which is already within the skilled person's repertoire. And so nothing has been contributed in a relevant sense, i.e. to the body of things that the skilled person can do or make. Proposition 5 is that Lilly's point of principle identified in its case was that it's not permissible in any circumstances to take account of information not known at the relevant date. And by the relevant date, I'm using that as a shorthand because sometimes priority is the relevant date, sometimes it's the application. In this case, it's the priority date. My lady, my lords, that proposition, which I rather detect they may have backed off a little bit from the oral submissions, is contrary to the basic scheme of patent law. It's contrary to all the judgments below, including the trial judges, and it's contrary to settled authority. Proposition 6, if that principle is a good one, it would apply whether the point was presented in combination with an argument about the unexpected benefit or not. So the point I make there is that my friend's case would be the same, and in fact, cases in the future will be the same if they someone will come along and say, you couldn't predict that 5 is where you would end up by routine methods, so I want a monopoly. And Proposition 7 gets me to what the case is all about. The reason the principle is wrong is that it extends to information that is in fact an important part of assessing what the skilled person is already able to do, i.e. that which is in their repertoire already. Let me explain why that's so. It extends to try to artificially exclude from consideration information that's not known at the priority date, but is routinely ascertained, not only using routine methods themselves part of the state of the art, but using them for a routine purpose towards a routine end. My friend has suggested today that the case raises serious issues for research using empirical but routine methods. And as we've said in our printed case, that puts the point far too broadly. At this stage, I simply want to make this point. What he's trying to do is extend his point to empirical implementation. Empirical implementation is what this is all about. And by that, I mean information that's ascertained in the course of and is inherently part and parcel of carrying out that which is already in the skilled person's repertoire. What my friend's argument does is opens up the possibility of repatenting areas which fall within empirical implementation, just because some further detail of how one routinely and empirically implements an earlier disclosure cannot be predicted before that implementation is carried out. My lady, my lords, it upsets the symmetry in the system because on the other side of the coin, when assessing the patentee's technical contribution for the purposes of sufficiency, you do take account of empirical implementation. And in fact, the point is vividly illustrated by the facts of this case when you strip them bare. The prior art publication, Dogan, basically discloses the use of tadalafil to treat ED, gives certain properties like its potency, making it particularly attractive, but it doesn't give the precise details of everything that the skilled person would need to do in order to use tadalafil to do that. But patent law doesn't require the detail to be given if it's within the skilled person's routine capability. And as I've just said, the sufficiency limb of the law allows a patentee to positively rely upon that as routine empirical implementation. And that is why Dorgan itself matured into a patent with Swiss form claims directed to the use of tadalafil to treat ED. We will come back to it, but very briefly, that patent is not insufficient because the patentee, the very same patentee that's standing here before my lady and my lords, is entitled to rely upon the fact that the skilled person knows how to implement its disclosure using empirical and routine methods. Yet they say, when it comes to assessing the technical contribution of Dorgan in the context of the validity of their later patent, you're not allowed to do the same. And that's what this whole case is about. It's all about a routine empirical implementation. Now, those are my 7 propositions with a little bit of explanation. Can I now stand back and move to the first substantive topic in my roadmap, which is the patent system as a whole? A very basic proposition is that it's all about regulating a bargain between inventors and the public. And I know that 3 of my lords know this, but it's worth reminding all of my lady and my lords that the scheme is to encourage technical development for the public's ultimate benefit. And basically, in return for its disclosure, so that it can be used after the monopoly, the public must refrain from acts within the scope of that monopoly for a limited period of time. And the reason I want to outline the basics of the scheme is because I want you to see where obviousness fits in and what part it plays in the balance that's struck, because it is a finely balanced system. And as I've already foreshadowed, there is a symmetry in the system, and that is a consequence of the central role that the concept of an enabling disclosure plays throughout it. So as I've said to my lady and my lords, the whole of patent law is concerned with technical information that is of use in industry. It's all about information enabling the making of products or the carrying out of processes. And my lady and my lords will see how we tried to summarise that point in paragraph 7 of our printed case. That's on MS 192. It's 3.5 lines. Now, inventions are themselves technical information. And my lady and my lords know that we're focused on the law of validity, but just as an introduction, the law of infringement is all about the use of that information during the time-limited monopoly without the patentee's consent. And as regards validity, that too is all about information that is of use to make products or carry out processes. Let me draw attention to a few aspects of that. Prior publications relevant to lack of novelty or obviousness are technical information. So too is the detail of the disclosure in a patent itself that may be relevant to assess sufficiency. Similarly, the common general knowledge that we're speaking about as being that of the ordinary skilled person, that is what they bring to bear in all areas of patent law. It's the information or knowledge the skilled person brings to bear in seeking to implement the patent itself, and it's the same information we equip the skilled person with in the assessment of novelty and obviousness. The information that this case is about is that which the skilled person doesn't already have in his or her head, but which is elucidated as part and parcel of routine empirical implementation. And I can show, my lady and my lords, that my central basic point is good by looking at some of the sections in the Act. My basic point about it being all about technical information to make products which are useful in industry. If we go to Authorities Bundle, tab 80, MS 3415, we see it reflected, for instance, in the section requiring inventions to be of industrial applicability, which my lady and my lords will see section 11C, which is amplified in section 4. So you see that on page 3416 and 3417. We see it also in the quality of things which are excluded from patentability in section 1.2. So that's on the left-hand side in bundle 8, 3416. You see there's a list of things which are excluded: aesthetic creations such as musical or artistic work, abstract ideas like mathematical methods or rules for playing a game or doing a mental act, or business methods, all excluded as such. So, for instance, one cannot patent an opera, even though it may be novel, non-obvious, and you can make copies of it industrially and sell them. What this system is about is the ability technically to make different products and carry out different processes. And in fact, you see that in a section which is not actually in here, but every patent claim, every invention is either a product or a process. Now, what is the basic scheme? How does it work? My lady and my lords know that we have the person skilled in the art. That's the patent law equivalent of the man on the Clapham omnibus. It's the person who we judge the quality of the disclosure of the patent and what they would do in the light of the prior art, and it's also the person that construes the document. That person is the representative of the public. In many cases, it's a team, and in fact, in this case, it is. It's a team of a clinical pharmacologist and a clinician. And I'm going to come on and deal with the point that my friend has made, putting against me. When we look at the key aspect of this case, it's all about the pharmacology, and that's why we had a pharmacologist. But I'll come on and address that tomorrow now. But it's a team in many cases, and it is here. Now, there are 4 principal requirements of patentability, or to put it another way, 4 objections to the validity of a patent. The first 2 are sufficiency and added matter, and they're sometimes referred to as internal validity because the focus is the information in the patent itself, or when one's looking at added matter, including the information in the application too. And the other 2 are novelty and inventive step. And sometimes they're referred to as external validity because the focus is whether the claims cover something already in the art. And the big picture point I want my lady and my lords to see is that the technical contribution is the additional class of products or processes that the skilled person is put in possession of by the patentee's disclosure. And when one is concerned with assessing sufficiency, the claim cannot extend beyond the technical contribution operates such that, that principle, such that it may not extend beyond that which has been enabled by the disclosure in the patent. When it comes to novelty and obviousness, it must not extend to that which is already available in the skilled person's repertoire. And novelty and obviousness are linked objections because they are both performing that latter part of the picture that I'm explaining to my lady and my lords. The idea is not only can the public do precisely that which was already made available by earlier publications, but they're entitled to do that which is obvious over and above it. And I can show, my lady and my lords, just by way of an example, where you can get that proposition. It's in many cases. I'm going to show it to you in Mr. Justice Laddie and Brugger. It's Authorities Bundle 2, tab 13, and it's MS 1356.
Could I have the MS number? I'm sorry.
Sorry, 1356.
1356.
Yeah.
Thank you.
And it's the second paragraph, the first 6 or 7 lines of it.
So which is the case? What's the name of the case?
Sorry, Brugger and Medicaid.
Thank you.
And it's tab 13. And if you can just see in the first 6 or 7 lines, Mr. Justice Laddie explaining that the point of the policy behind the law is that the public should be entitled to do things which are obvious over and above that which has already gone before.
Sorry, which lines are we looking at?
I'm looking at the second paragraph, the first 6 or 7 lines
Right.
of that paragraph, so it's probably line 13
Yeah.
down to about
Yeah.
20. And that's actually what the well-known Gillette defence in patent law is about, which we've mentioned in our case. I'm not going to ask you to turn it up, but very briefly I'll explain what the principle is, because patent lawyers call it a squeeze. And if you've got a case where there's a dispute over both infringement and obviousness, if you establish that the alleged infringement is an obvious modification of the prior art, you win. Because if it's within the claim, it's obvious, because you've established that. Or if it's not within the claim, sorry, get it the other way around. If it's not within the claim, there's no infringement, but if there is, it's obvious. And so that's why the Gillette defence is a squeeze in which you actually run an argument saying, what I'm doing is obvious over the prior art. And we've given it to my lady and my lords in the bundle. It's actually the speech of Lord Moulton at MS 1643, bottom half of the page, but I'm not going to ask you to turn it up. But that's the guts of what that point's about. Now, one of the things that I think my lady and my lords know is that the assessment of the validity of a patent raises an antecedent question, which is the correct date, which I've just foreshadowed, and that's the priority date. And priority is a scheme where an initial application can be used to gain a year's grace so that you can file as many applications for national patents around the world as you like using the priority claim from just one national patent. And the requirement for a good priority claim is that the initial filing, referred to as the priority document, discloses the same invention. And as we shall see, priority is also all about what is enabled by the priority document. And in fact, what we shall see is that priority can apply to prior art too. It's part of the regime that deals with conflicting applications which are not published. And under section 2.3 of the Act, the prior art document also has to have or can have a priority. So let me just show you that. tab 80, back in volume 8. And so it's MS3416 that we were looking at earlier. And you see section 2.3 deems matter in another patent application, so not the one that's actually in dispute before you, but another one, is deemed to be part of the state of the art for novelty only. We'll come back to that because my friend makes some point on that. And the conditions include that it has to be both filed and published, but also the priority date of it has to be earlier than that of the invention. So priority is all about exactly the same thing. Information that enables products or processes to be made, both when it comes into play for the prior art assessment and also for the patent itself. Now, can I show you those three important cases, all at the highest level, which I hope will give you an insight into the big picture that I want you to see. And I'm going to take them in date order. The first is Merrill Dow, and that is in the authorities bundle 4, tab 38, MS 2094. And a warning, this is the hardest case that I'm going to take you to. It's all downhill after this.
What's hard about it?
Well, there's a little bit of esoteric reasoning. If my lady doesn't find it hard, then I'll be delighted. But, it's a case about an antihistamine. It was called tafenidine, and the dispute in the case arose because the original patentee for tafenidine subsequently patented an acid metabolite. And we can see that summarised in the paragraph on MS 2098 between lines 25 and 35. And the metabolite is obviously a chemical that the body converts tafenidine into. And it turned out that the therapeutic effect that tafenidine had been giving people was actually due to the metabolite. But nobody had identified it before, this second patent, and it was the second patent which was the patent in suit. So what was old was taking the pill, I think it was your liver turned it into something that did you good, and they found that out and then patented that separate chemical. And what they were saying, Merrill Dow, the patentee, they were saying that its original monopoly on tafenidine was extended by the subsequent patent. And just to get the timescale, you can see the tafenidine patent itself expired in 1992. If you're on MS 2098, it should be between lines 20 and 22. And at line 26, you see that the latter patent had another 5 years to run, and that was in 1995, so it would have expired in 2000. So they were trying to get an extra 8 or so years. And the wheeze was to allege that the sale of tafenidine itself was caught by the second patent. You see the detail of the argument at the bottom of page MS 2098, because they argued that patients inevitably made the drug in their bodies by taking the old tafenidine. Not surprising, that's what a metabolite is. And so the argument was of supplying means essential under section 60, subsection 2, saying that the people supplied would then put the invention into effect. And it's really important to understand that the infringement argument had to treat the taking of tafenidine and metabolizing it into the metabolite as an act of manufacture. So how can the latter patent be both valid and infringed? Well, my lady and my lords will be pleased to know that your instinctive reaction that Merrill Dow's case couldn't be right did prevail, but as we shall see, the care evident in Lord Hoffman's judgment shows that in fact this was one of those points that's more easy to feel than to provide an explanation for. Because the claim in the patent was to a compound that was therapeutically useful and nobody had identified it before. And it's cases like this in my submission that require us to stand back and look at the bigger picture, and that's exactly what Lord Hoffman did. Now, if you go to page MS2100, you see Lord Hoffman beginning with what the invention was. This is line 36. It was the metabolite as a product.
Line,
36.
okay.
Does my Lord have it? Yep. And he explained that any way of making it was in the monopoly. And you see he explains at the end of the paragraph at line 45 that it matters not if you knew you were making it. We see that the last two lines of the page, the corollary of this is that the novelty must be coextensive with the monopoly. And actually that, in my submission, is just another way of making the point about the technical contribution being commensurate with the monopoly. You see the intuitive response, which is one of incredulity. I can never say that word.
Incredulity, I think.
And you can see that's explained in section 6 at MS2101, in particular the passage around lines 27 and 30. And the point was argued that under the old law, so that's up before the 1977 Act, a claim lacked novelty if the product or process had been done before. So it was argued the new law, that's the EPC, that the new law no longer stopped a patent covering that which had been done before. And you see that argument at MS2102, line 11. And you see a little bit further down at line 15 that the argument was that information about what was being done should be made available to the public. And so Mr. Thorley's argument went, there was no information about the metabolite. This is line 16. Now, Mr. Thorley pointed out and relied upon section 64 of the New Patents Act, which had been introduced to give a personal right to do an act if that person had done it before the priority date or had made effective preparations to do so. And that's line 20 to 21. And you see in the paragraph at the end of this section, so that's line 30 to 35, His Lordship explains what I've foreshadowed, that this is not an easy thing to explain why Mr. Thorley's arguments were wrong. His Lordship says they're serious arguments. And before looking at the law, His Lordship explained that there were two arguments in this case as to anticipation. And I'm at the foot of MS2102, lines 45 to 50. One was anticipation by use, and that's basically by giving it to volunteers in clinical trials. They were just given the pills and took them. The other was by disclosure of the old tafenidine patent. In both cases, it was obviously tafenidine, and the use argument was dealt with first, and you see the section considering this under the old law, the 1949 Act, in the passage bridging pages MS2103 and 2104. And just very briefly, the point was that in Bristol-Myers-Johnson's application, the House of Lords had considered whether secret or uninformative use was enough to anticipate, and it held that it did. And you see that at the passage at the top of MS2104. So very briefly, if something had been done before, it didn't matter if it was secret or uninformative, it was enough to anticipate. But as we shall see, that is not the new law. Secretive or uninformative use doesn't count. Can I pick up the explanation in MS2104, line 28? His Lordship explains that under Article 54, the invention must be made available to the public. And he explains, something I've said in one of my propositions, an invention is a piece of information. To make it available to the public, therefore, required communication of the information. That's down to line 34. And so the last sentence in that paragraph is that use of a product makes the information part of the state of the art only insofar as that use makes available the necessary information. The explanation between lines 37 and 44 was that, indeed, the new law had opened up a gap between infringement and anticipation. Secret or uninformative use, which would count as an infringement after the patent, would not count as an anticipation. But of course, we've seen that there was a possibility of the Section 64 defence. Now, His Lordship then referred to two authorities that supported his construction of Section 2.2. And the first mentions something which is pretty obvious, that in most cases the sale of a product does make available information as to its content and method of manufacture. That's MS 2105 at line 5. And His Lordship concluded at line 26 that Mr. Thorley was right, that one cannot dismiss his argument on the basis that the making of the acid metabolite had happened before. So to that extent, the intuitive response was wrong. Line 30 of MS 2105 turns to anticipation by disclosure, and that was the original Tadenophene patent, which had been published before the priority date. And the first thing that His Lordship drew attention to was that this was different because it depended upon communication of information. And that's MS 2105, line 36. And Mr. Thorley's argument under this head was set out at lines 40 to 47. Basically, if the disclosure said nothing about the existence of the metabolite, therefore the reader didn't know about its existence and couldn't know how to work the invention. So the argument is the acid metabolite hadn't been made available to the public. Then there's a discussion over the next two paragraphs. This is the foot of 2105 over to the top of 2106, which is basically making this point, that one can know a thing under different names. And this is important. The top of MS 2106 illustrates the point with a homely example of a prize-winning rose grower that also happened to be a VC holder. It's an important point to grasp, not just for the Merrill Dow case, but also it's important for our case. And the point is important because of this. One can identify something under a description that is new, even unexpected, like the knowledge that the village rose grower was a VC holder. But that does not mean you have identified anything new or anything non-obvious. And the point is made colourfully by the explanation that follows about the indigenous Amazonians who knew the cinchona bark could treat malaria. French scientists later discovered that it was quinine, and even later their chemical formula. I'm looking now at lines 8 to 13 of MS 2106. But if asking whether the Amazonian knows about quinine and its quality to treat fevers, you see, His Lordship explains that they do, even though they may refer to it as the magic of the bark or some other label. Now, if my lady and my lord skip down to lines 50 to 52, His Lordship asks if patent law has its own epistemology. And you see over the top of page MS 2107, Mr. Thorley was arguing that in effect it did, and that the law required you to know the thing by its chemical composition. And the answer His Lordship gave in the short paragraph MS 2107, lines 13 to 17, was all that was necessary was to know the invention sufficiently to work it. In other words, being enabled to do something which is within the claim. And the conclusion in this case, which you see at the foot of MS 2108, around lines 46, was that the earlier patent did enable the public to work the invention by making the acid metabolite. Because they could make the drug and they could ingest it and thereby make the metabolite. And that's why I said right at the beginning it was important to grasp that the infringement argument required that to be working the invention. And before we put that case away, just a little bit further up on MS 2108, you can see His Lordship was considering the EPO flavour concentrates decision, that's line 8, where there was a similar point. And the point there was where there's a recipe that's in the state of the art, so the substance that's inevitably produced by that recipe is also in the art. And it doesn't matter if you don't know its chemical formula. Now, the reason I say that's really quite an important point here is because part of my case is that finding out more information about something that the skilled person would do without invention doesn't add to that which can be made or done. There is not an additional person when you identify the VC holder. It's the same man that was known before under the label the prize-winning rose grower. Now, my lady and my lords, the next of my three cases is Biogen, which is in Bundle 1, Authorities Bundle 1, tab 9, and that's 1190. And this was a case about genetically engineered antigens of the hepatitis B virus, and it's a case where the width of claim that the disclosure could justify arose in both the context of priority and sufficiency. And it was a case where the contribution was one way of getting to the known goal of genetically engineered hepatitis B antigens, but it claimed all ways. And Lord Hoffman addressed priority first, and that starts at MS 1235. And at the foot of the page, you see a reference to a case called Asahi, which is also in the bundles, but given it's covered here, I'm not going to take you to it separately, just to save time. It's in the same bundle, Authorities Bundle 1, tab 7, and it's MS 1078. But you see, from Lord Hoffman's explanation at the foot of the page, that the House of Lords decided that for priority, there must be an enabling disclosure, i.e. the priority document must provide information that enabled the skilled person to perform the invention. And you see at the top of the next page, MS 1236, Lord Hoffman explains that the concept of an enabling disclosure is central to the law of patents. And he explains that for his purpose, it touches matters at 3 points. Support for Section 5. Secondly, it's required for a valid application. And third, it's essential to one of the grounds of revocation, that's insufficiency. And I'm going to come on and show my lady and my lords that in fact the concept of enabling disclosure is even wider in application. It pervades all, including novelty and obviousness. His Lordship went on to address the question of the scope of the claim over the top on page MS 1237. And he referred to the well-known EPO case of Genentech polypeptide expression, which was a case of an invention of wide general principle. And I can pick it up at the foot of page MS 1237, where Lord Hoffman explains that the result in Genentech is no more than a reflection of the requirement that there must be enablement across the full width of the claim. So if you provide a general principle, the claim can be that wide. If you don't, it can't. My lady, my lords, what that is basically saying is if by your disclosure you put the public in possession of a wide class of products or processes, you can claim it, not otherwise. It is about the class of products or processes that you are adding to the skilled person's repertoire. And in this case, you can see the result if you skip forward to MS 1239. It's the well-known paragraph explaining that in that case, the claim didn't wasn't commensurate with the contribution because it covered other ways to, quotes, deliver the goods that owed nothing to the patent. Now, the same reasoning applied to sufficiency that my lady and my lords will see if you go over the page to MS 1242, led to the conclusion the patent was insufficient as well. I'm looking at lines 20 to 26 at the beginning, just under the heading sufficiency. But there's also a further passage of note in this short section where His Lordship held that the date for assessing sufficiency was the application date. It's difficult to believe now, but there had up to then been authority suggesting that it was later, the publication date. But His Lordship held that the application date was the correct date, so as to enable the power for revocation to be exercised if the monopoly exceeded the technical contribution described in the patent. And that's over the page on MS 1243, lines 5 down to about 14. And if you think about it, what that's actually doing is stopping a technical contribution being supplemented, not by changes to the patent itself, which is what added matter stops you doing, but by an advance in the common general knowledge. So, what that case is getting at is, as regards sufficiency and priority, what's important is what you've given to the public in terms of the technical contribution, and your claim mustn't go any broader than that. Now, the last of my three cases is Synthon, and it's perhaps the most important of them all. And it's Bundle 5, tab 52, MS 2606. It's to do with lack of novelty, or often called anticipation, but it's perhaps most important because of the short judgment from Lord Walker, explaining how enabling disclosure is part not only of the law of sufficiency, but also the state-of-the-art paragraphs, making it clear he included section 3, i.e. obviousness in this. It's a short but learned opinion that we'll get to, and it's one in respect of which my lady may recall specifically expressing some gratitude. It was a case that my lady was in.
I know.
And the case was about a drug called paroxetine methane sulfate, or PMS, and a particular sort of paroxetine, and it's used to treat depression. And what happened is that this particular drug had been more or less simultaneously discovered by two pharmaceutical companies. And we have a first-to-file system, and so it was a tangle where both of them filed. The filings were just over a year apart, but by the time of the second filing, the first had not been published. So in fact, it wasn't part of the state-of-the-art, but it was an earlier filing. And actually, ordinarily, it would be relatively straightforward, and the first-to-file would prevail. The earlier application is treated as part of the state-of-the-art for novelty in the section that I've just shown you, and its disclosure would anticipate the later filed document. But the issues arose in this case because of errors in the first filed document. It wrongly said that the salt existed in different crystal forms, and it purported to provide an infrared spectrum to identify the right crystal, which was itself in error. And it also described creating crystals using a method which used a solvent which in fact didn't work. So quite a lot had gone wrong. And the later filed document described PMS and gave a different IR spectrum. And this you can see in paragraph 9 at MS 2611. And so a person actually reading the documents would think that the respective teams had identified different polymorphs. And all that means, that's a fancy name for just meaning two different crystal forms, but different inventions nonetheless. The earlier filed document was Synthon's, and the later one, SmithKline-Beecham, referred to as SB in this opinion. And Synthon had sought to have SB's patent revoked, and so the dispute was whether the earlier disclosure did in fact anticipate the claims in the later filed patent. And if you look at paragraph 13 on MS 2612, you see it's a case under section 2.3. And that's the one I showed you about deeming matter filed but not yet published to be part of the state of the art. And just as an aside, that was a policy decision that the framers of the EPC had to make concerning what to do with co-pending applications. And the law adopted a compromise such as they counted for anticipation, even though they weren't in fact in the art. And it stops double patenting in the sense of a different applicant getting claims to exactly the same invention. That would lead to perhaps both patentees not being able to exploit their invention. And so it stops that. And that wasn't a decision that was made for obviousness. Section 2.3 applies only to anticipation. But if we go to MS 2613, we see Lord Hoffman's summary of the argument before Mr. Justice Jacob, and I can pick it up at paragraph 16. And having just described how the best organic chemist in the world, working with the best practical organic chemist he'd ever worked with, had failed to make the crystals from a solution of the kind described, he describes the evidence advanced before Mr. Justice Jacob. First, they explained that the IR spectrum was an error from their own laboratory, and the evidence and argument that PMS was in fact monomorphic. That means there is just one crystal form. So the point of that was that the disclosure of a crystalline PMS form necessarily meant the crystal of the patent in suit. And the judge accepted this, as you see from the middle of paragraph 16. Paragraph 17 deals with enablement, and you see that the issue was the solvent described actually did something to inhibit crystallization. This is between letters F and G on MS 2613. But the argument was that the skilled person wasn't confined to a particular solvent and would try another. Crystallization commonly involved trial and error, and luckily for Synthon, even SB's patent had also characterized this as conventional and being something that's capable of being affected by a variety of solvents. That's letter H. And Mr. Justice Jacob accepted that argument too. So the effect was the very product being claimed was disclosed in the earlier application, and the making of it was enabled. That's the end of para 18, bridging MS 2613 and 2614. And Lord Hoffman's explanation of the law starts at para 19 at MS 2614. He addresses disclosure first and summarises the effect of two well-known statements, and that's para 22. And it's basically this: it must disclose subject matter which, if performed, necessarily results in infringement. You see, about letter D, Lord Hoffman explains that one doesn't have to know that this is so. It's a question of fact as to whether you're within the claim. And he goes on and refers to the Merrill-Dale case in paragraph 23, reiterating in the middle of that paragraph that the infringement must necessarily be entailed, not just possible or even likely. And at letter F, you see that if there's more than one possible consequence, one cannot say performing the disclosed invention will infringe. But importantly, for our purposes, he points out that it may still be obvious. That's just above letter G. Of course, in that case, wouldn't have worked because it wasn't available for obviousness. But in our case, the disclosure is. My lady, my lords, enablement is addressed from para 26 onwards. And you see, para 26 itself, the statement that this applies whether this is a section 2.2 or section 2.3 case. So that's art relevant for novelty and obviousness. And importantly, in the middle of paragraph 27, Lord Hoffman also draws attention to the fact that enablement is used in other contexts in the law of patents. And he draws attention to section 72(1)(c). That's the sufficiency requirement in the section revoking patents. Let me just as an aside make sure you're aware that that comes up twice, both in the section for revocation, but also the section directed to the Patent Office in granting patents. The equivalent is section 14. So when you see section 14, it may also be sufficiency. And you see the well-known extract from Valenci referred to. And you see that in the context of sufficiency, it said the skilled person must be able to display a reasonable degree of skill, making trials and correcting errors. So for sufficiency, that clearly allows what I've referred to as empirical implementation. And have regard to what you find out in your routine seeking to implement the directions. And can I just pause there and say that's not because you're somehow illegitimately supplementing the disclosure of the patent in assessing sufficiency. It's because you're assessing what the skilled person can do in the light of the information that's actually in it. And I say it's exactly the same in answer to my friend's suggestion that my approach is to illegitimately add information to the state of the art for the validity attack. And it applies in my submission whether one's considering obviousness or lack of novelty. And the parallel in this case with sufficiency is emphasised further by reference right at the foot of this page, 2616, to Mentor and Hollister, another very well-known case on sufficiency. And then at letter J, at the foot of the page, His Lordship says the tests are the same. That is prior disclosure for anticipation and sufficiency of a patent. He goes even further at the top of MS 2617 and explains that the authorities on sufficiency, section 72(1)(c), are applicable to enablement for the purposes of section 2.2 and 2.3. And we know from section 3 on obviousness that section 2.2 is applicable to both novelty and obviousness. Now, Lord Hoffman explains at paragraph 28 that it's important to keep the two concepts distinct. That's disclosure and enablement. And he cites an extract from Mr. Justice Laddie explaining that one can have one without the other. And incidentally, that's one where the example used is section 14 rather than section 72. And a point we've seen already, Lord Hoffman goes on in paragraph 29, explains that in many cases, making a disclosure is enablement. And he gives an example of a dumb product where you can look at it and take it apart. But this was a case where it mattered. And in applying the law to the facts, the Synthon application did disclose crystals of PMS. You see that from para 35 on MS 2619. which on the judge's finding was only one thing, so they had to be the crystals of the SB patent. That's the end of para 36. And on enablement, the question becomes whether the skilled person was able to make crystalline PMS, which was a question of fact, which, as Lord Hoffman pointed out in the middle of para 38, that's between H and J on MS 2619, involved the standards laid down in cases like Mentel, i.e. sufficiency cases. Now, Lord Walker's judgment merits attention, as I've already said. It starts on MS 2623, paragraph 56. And can I pick it up at 59, where his lordship's picking out the key sections for his explanation as to why the requirements of disclosure and enablement are part of the law. And we see he picks out section 1, which is the overview, then 2, 3, 5 and 14. And he specifically mentions 72, but only because it covers the contents of those earlier sections. Quick checklist. Section 2 is novelty. Section 3 is obviousness. Section 5 is priority. Section 14 includes sufficiency. And at para 60, his lordship sets out section 3, that's obviousness, that identifies section 2 applies but not section 2.3. And after explaining the relevance of section 5 and 14, that's priority and insufficiency, that's through paragraph 61, his lordship identifies the key issue at paragraph 62, right in the middle of MS 2625. And the point is this: how far an enabling disclosure is required implicitly in statutory provisions expressed in different terms from section 14. Section 14 is where it's there expressly. And at about letter E, he specifically draws attention to section 2 and 3. So that's both novelty and obviousness. Paragraph 63 is absolutely key in my submission. What his lordship explains is the concept of an enabling disclosure is a compendious summary of two distinct requirements which arise as a pair. And that's disclosure and enablement. He says that they arise in different statutory contexts, explicitly in section 14 and implicitly in determining the state of the art for the purposes of section 2 and 3. And that's really important in my submission because in substance it's another way of putting my big picture proposition that patent law is all about information that enables the skilled team to make products or carry out processes. And at the end of this key paragraph, Lord Walker points out that there's a symmetry in the law. What he's referring to is that this concept or pair of requirements comes in determining both sufficiency and validity over earlier published information. And in both cases, it's all about what is enabled. In the novelty or obviousness case, obviously without the patent, you're looking at what you can already do in the light of the state of the art, what's in the skilled person's repertoire, and in the case of sufficiency, with the benefit of the patent. And as I think I've already foreshadowed, as an aside, I would also add, it's exactly the same when one's looking at those priority documents, whether you're looking at whether someone's filed something to be able to claim priority, or whether you're looking at an earlier piece of prior art under section 2.3. It's exactly the same. Enabling disclosure is key. And Lord Walker finishes by pointing out that one needs to be careful with the composite expression because they're two distinct requirements. In some cases it won't really matter, but there will be cases where it does matter, and this is para 64 bridging MS 2625 to 2626. And when one comes to the enablement test, you are allowed for the skilled person to learn from his mistakes. And you see that on MS 2626, a little bit above my lady's concurring opinion, right at the end of para 64. It's quite general in my submission, clearly applying to each of sufficiency, novelty, and obviousness. Now, my lady, my lords, that is a recognition that one can take account of information that you may ascertain by following a disclosure, seeking to implement it. And doing so is as applicable in the case of lack of novelty or obviousness as it is in the case of assessing sufficiency. When one's concerned with obviousness, we are of course concerned with a disclosure that's enabling but leaves some detail to the reader, either to have that idea if they're making a change or simply to fill in the detail using empirical techniques. But you're still concerned with what class of products and processes the skilled person is enabled to make or do as a result of that earlier publication. So what do you get from this whistle-stop overview? In my submission, it's the following. The whole of patent law is about information that makes a difference as to what the skilled person can do practically. The basic and fundamental principle is that the technical contribution must be commensurate with the monopoly. All of the conditions of validity go to that, including novelty and obviousness. I might have cited a paragraph from my Lord Sumption's judgment from last week on that. I think it's paragraph 17. It matters not in my submission if the skilled person knows that what's being done is within the claim. It's a question of fact. All that matters is if the information made available places the products or processes, or just some of them within the claim, within the skilled person's repertoire. And when assessing what the skilled person is enabled to do or make, the same test applies when you're looking at sufficiency and what they can do in the light of the prior art. That is not an illegitimate supplementing of the knowledge that is the knowledge that you're supposed to be considering in either case. It is the way in which you assess what the skilled person is thereby enabled to make or do. Can I move on, unless you have any questions on that, can I move on to the basic technical facts? Actually, just to pause, I want now maybe just a time to give my lady and my lords just one sentence. What I hope you see is the way I'm going is that Dorgan discloses the use of tadalafil to treat ED. It leaves
Discloses.
the use of tadalafil to treat erectile dysfunction. It leaves to the skilled person and their common general knowledge how one seeks to find the appropriate dose. And it's routine. The judge held that it was very likely that doing that would get you in the claim. And frankly, when I show you the evidence, you'll see why. It would be quite extraordinary not to, but he did hold that it was not inevitable. But that doesn't matter for an obviousness case. What my learned friend is seeking to monopolise is not only an obvious way to implement Dorgan on dosing, but the completely bog-standard way to do it. And he seeks to do that by saying that you didn't know what the dose was before you did the routine empirical implementation. That's what the case is. So he says he can have another monopoly on the most obvious way of doing it. And you'll see a flavour of that when I take you to the key technical facts now.
What do you mean a monopoly on the most obvious way of doing it?
Right, because the way of implementing Dorgan requires you to find an appropriate dose. The purpose of the routine dose studies, each of the steps that was routine had a purpose. Key one is phase 2B. And that purpose is to find the dose response, which I'm going to explain to my lord in a minute. And if you actually did do that, so if you did the routine studies for the routine purpose and you completed them, you'd be within the claim. He has to rely upon a suggestion that you might stop before you've done it.
But how would carrying out the studies be within the claim? I mean, could anyone claim that if someone now did a phase 2B study on tadalafil and discovered, if it weren't already known, that it had this effect, would that be breaching any patent?
What you end up doing is, I'll show you the facts, but you do treat people with a particular dose to see whether there's efficacy.
Yes.
And you see, very briefly, I'm going to explain it, but you see that you're on the top plateau, i.e. that there's no variation, until you go to 5. So you have treated somebody and you find out that there's efficacy by doing what is the standard thing to do. And you don't stop until you've found it.
I understand what you're submitting. You're saying that it's enough that it should be obvious to find an optimal dosage from the various points of view, efficacy, safety, etc., and to expect that you will find an optimal dosage. You don't have to go further and show that the skilled person is expected to find the particular optimal dosage that results from this process.
My lord will be pleased I'm not shooting that down. That's exactly my submission. Absolutely my submission, and we'll see it said, something similar is said in the context of surprising effect. It's not whether the thing itself is surprising or unexpected, it's whether discovering it is obvious. And actually, if you stop and think about the policy, you do end up, as I've just said, he's relying upon the fact that it's not inevitable that you do it this way. He says it's very likely, not inevitable, but he's actually claiming the monopoly on the very likely way that a skilled man would do it. The most obvious way.
On that submission, what do you say about Mr. Waugh's submission? Because the claim is framed in terms of the answer to the process, that's the thing you've got to expect.
Right.
To show.
Right. It's a very simple answer to that, and I'm going to show you the cases, but the test is whether it's obvious to do something within the claim. First question, what is obvious to do? Second question, is it in the claim? Not, can I predict the words of the claim, and it's obvious to set out and do that. So it's a very simple answer. It's just like anticipation. You don't need to know that what you do is within the claim. If it's obvious to knock on the door of the prize growing, the prize rose grower, the claim to knocking on the door of the VC holder is obvious. Because you do it. Can I start on the basic technical facts? And they're key to understanding the case. Tadalafil is an inhibitor of an enzyme called PDE5, and that's a property that sildenafil, more well known as Viagra, had, and that's how it worked. The potency of a drug is illustrated in the statement of facts and issues by a graph. Let me just get you the page number. It's page MS112, so it's paragraph 19, and this is just a generalised explanation of any effect. It's not even efficacy at this stage, it's just any effect. And you see the general shape of a curve is depicted, and it could be any response. It's just anything that a drug may do. It's a semi-log scale, which means it's been concertinaed up on the x-axis, so instead of a fixed number of units, it's a factor of 10 every centimetre or so. And it's just a conventional way of showing something which would otherwise be quite a long graph. The next thing that you need to know to get an overview is second in class. Tadalafil was following along behind sildenafil, so it's known as second in class, and there's an enhanced expectation of success where it's a second in class, and that's simply because you know something else that's the same property, PDE5 inhibitor, so you're more likely to think it's going to work. The standard way in which those skilled in the art seek to implement directions or proposals to use a drug for a particular condition is to follow the well-trodden phases that are described in para 30 to 33. This is all common general knowledge, and very briefly, what you do is first put it into people who are healthy. That means they don't have the condition you hope to treat, but you get information on tolerability and safety at different doses, and other information about an area called pharmacokinetics, and that's things like how long it's in the bloodstream, how long it stays there or is cleared out. In this case, tadalafil has a much longer half-life than sildenafil. It takes nearly a day, I think it's 17 or 18 hours, for half of it to be cleared out. That's the half-life. And sildenafil was 3 or 4. And it's that which makes it suitable for daily or chronic dosing. So that's phase 1. You haven't put it near anybody that's got the disease that you're seeking to treat. Phase 2 is when you start to do that. And that's split into 2 parts. Phase 2A is a single one-off go or no-go. It's the first time you try it in people with the illness, and the first time you see anything about efficacy. That's para 32 in the statement of facts and issues. And generally you go high. By that I mean you go to a dose which has the best chance of showing efficacy. And if you do phase 2B. And that's where multiple doses are tested. And this is paragraph 33 on MS 117. And that paragraph is very important. It's very important because it explains that the idea is to show an effective dose, i.e. where higher doses give a bigger clinical effect than a smaller dose. Absolutely crucial. This paragraph also explains that this is a matter primarily for the clinical pharmacologist, obviously working with the clinician, but it is primarily the clinical pharmacologist. So my learned friend trying to make some point about a clinician not coming along and saying, I could have guessed the dose would have been 5, really does add nothing to his case. The last bit of this paragraph, the skilled person is familiar with multiple dose ranging studies as necessary. That's another thing that's important. Phase 3 follows on after this and is what generates the data for regulatory approval. But the key to this case is phase 2B. And it's key because all you've got to do is phase 2B with the idea that's recognised in that paragraph. And what we've tried to make sure you understand in our written case, and it's quite important given the way my friend continues to muddle up minimum effective dose or lowest effective dose and dose response, is there's a difference, and they're not finding the dose response as such is not the same thing as finding the minimum effective dose. And so if you turn up MS 208, what we've done is drawn in effect the well-known sigmoidal shape, which basically is just a slightly slanty S shape. the dose response region is labelled in the middle. That's what the skilled person wants to find. The top plateau is on the top right and the bottom plateau is on the left. Top plateau is where if you give more of the drug, the efficacy is the same. The bottom plateau is basically, it doesn't do anything better than placebo. So you always get some effect because you're giving someone pills, but nothing that's actually better than placebo. And the thing that is different is the minimum effective dose, which we've simply tried to illustrate as it's broadly towards the bottom of the dose response. It's the dose, the smallest dose, that gives a clinically relevant effect. And I don't want you to understand that I'm saying it's definitely there. It may be a little bit further up or a little bit further down. But my case at trial was that it was routine to ascertain the dose response and, moreover, to look for the MED at the bottom end of it because regulators asked you to.
Is that because the lower dosage, the less the side effects?
Indeed. The way the findings of fact came out was that the judge said that it was the MED as a concept was common general knowledge, but the skilled person might not pin it down precisely. And so my case now doesn't involve the MED at all, but the reason I have to go there and explain to my lady and my lords what the difference is because what my learned friend does and what the judge did was muddle these two things up. And my learned friend, in some of his submissions to you this afternoon, started talking about the MED and the difficulties in making judgments as to where it is. Those are judgments which are absolutely nothing to do with the question of whether or not you find the dose response at all. And that's the point, because when we come to the findings of fact, I'll show you, and the reason the Court of Appeal said it's just down to one thing, is that until you get to 5, you're on the top plateau. So just at this stage, all I want my ladies and my lords to get is that the MED is different to the dose response, and my case does not depend upon any part of finding that, although it's definitely right to say that at trial I was saying not only do you find the dose response, but you find the bottom end of it. And so there is only one value judgment that is conceivably relevant to whether the skilled person does something in the claim. It is the decision, if one can really call it that, to do dose-ranging studies in the way that they are intended, i.e. to find the dose response. And my friend sought to make much of saying, oh, it's only very likely. Well, very likely is far better for me than simply obvious. Indeed, it's not inevitable, but very likely is why I say to my lady and my lords that it is the bog standard way to do it. And another thing is that I shall show you that the judge held the skilled person would be very likely to go to 5 milligrams, both implementing an on-demand regime and a daily, i.e. chronic one. I think you're aware that the claim covers both. It does not distinguish. Just because it says what the maximum daily dose is, that does not mean that it is limited to chronic dosing. And this is going to be an important part of looking quite carefully at how my friend characterises his invention. But perhaps I can leave you with just this before we stop. The judge held that the claim covered both, and that's actually why he went on and considered both, which I'll show you tomorrow. But if we could just turn up the judgment para 122, MS 361. It's important because my friend does box and cocks a little bit as to whether he wants to say it's all about the magic daily dosing. The claim is not so limited.
Paragraph.
122, it's a three-liners about just above halfway down on MS 361. So I'm going to finish tomorrow on this topic, my lady, my lords, and basically my submission is going to be that there is just one road and it leads to Rome, but my friend's case is that the judge held it's conceivable the skilled person might stop before he gets there. And he wants a patent on what he finds when he gets there.
And just so I've understood you, you say the only value judgment which would lead to not getting to investigating the dose response would be failing the go, no-go test at 2A.
No, it's not even that. It's the deciding that when you go into 2B, you just stop on the top plateau at some place before you've done what the purpose of it is. We know that you would satisfy the go, no-go. That's not a value judgment. Yeah. We know that the answer there is thumbs up, it works. The value judgment is you do your first test that doesn't include 5, say 25, and you stop there. That is the value judgment, not doing the purpose of the phase 2B. And I'll show you that value judgment was agreed by their expert to be a no-brainer. Exactly. And I'll show you that probably first thing tomorrow very quickly. And if you do that, you're in the claim.
Well, possibly you've got your money's worth out of your extra 2 minutes. We'll see tomorrow. Anyway, we'll adjourn now and look forward to hearing from you at 10 o'clock tomorrow morning.
Yes, I'm grateful for that.